Hello everyone. Welcome to Management 413, Employment Law here at the UAB Collat School of Business. In this video we will be covering an overview of employment law using Chapter 1 of our textbook. At the start of every video like this, I will be providing the topics that we will cover. I won't be reading those, but I suggest you stop and pause and look at those to make sure you know what's ahead. Employment law in the United States is actually a patchwork of laws from many different sources. There is no one book that you can go to find employment law. There are a great many variables that will influence which law that does apply to you, such as whether you are a government body, is there a union representing you? The law changes every single day. That's what the word dynamic means. Here are a couple of places where we can find sources for employment law. If you click through on those when you are viewing these slides as PowerPoint slides, they will take you to the actual sources. There are some rights that we have as employees in the United States under the laws of the United States. But the general principle is that we really don't have very many rights. There is a principle called employment at will that is in effect for most of us. It is a myth that as long as we do a good job, we cannot get fired. The doctrine of employment at will has been around for a very long period of time, and that would say that you as the employee can quit whenever you want, but it also means that your employer can fire you whenever your employer wants to do that. If there is a contract, which doesn't happen very often, then the employment at will doctrine would go away. We also get rights as employees in the United States under a variety of non-discrimination and equal employment opportunity laws that we'll be covering in the future. But it's important at this early stage in the course to recognize that not all discrimination is illegal. Take a look at the case in your textbook where someone who had a very good reason for using medical marijuana was fired for using marijuana by Walmart because using marijuana for medical purposes is not a protected class, is not a protected basis that will allow you to claim that you cannot be discriminated against. We also, if we belong to a union, have certain rights, and sometimes you don't even have to belong to a union. The formation of a union at a workplace can also be protected even before the union is in place. There are a number of other laws that protect the workers in the workplace. We'll be looking at these, such as the Fair Labor Standards Act, the right to be compensated if we are injured on the job. If you're the HR manager and you're trying to figure out which laws apply, the first place to look would be whether you are a public employer, such as a government or maybe a public university, or are you private? Are you unionized? What's the size of your organization? Where are you located? Do you have a contract with the federal government? And what industry are you in? If you are in a very hazardous industry using, say, making hazardous chemicals, you will be under a different set of laws than if you were not. Here's a chart that shows you that the vast majority of employers in the United States are actually very small, and the number of employees can affect the laws that apply to you. We really didn't have employment laws in the United States until the 20th century. That's because there was no such thing as business, or at least big business. Everyone before 1900 or so was pretty much a farmer or shopkeeper or teacher, and we didn't have organization with large numbers of employees until the Industrial Revolution took place. And the first legislation that was passed came about in the early part of the 20th century. For example, the National Labor Relations Act did not get passed until the 1930s. Here's a list of laws that have been passed over the years that regulate the employment relationship. Look at the very first one in 1900 was a law on, or laws on workers' compensation in various states, reflecting what was the most pressing social issue regarding employment, and that was people getting hurt on the job. Please watch this short video in the learning module about an event that many people think gave rise to the intense period of worker protection laws in the early 20th century. If there is a law that applies to you, how do you go about enforcing it? Well, first of all, you can go to court, but you better make sure you go quickly. We will be talking about the Lilly Ledbetter Fair Pay Act. This is Lilly Ledbetter from Gadsden, Alabama, and President Obama on his very first day as president. He oversaw, even before he was elected president, a law that gave more rights to people like Lilly Ledbetter to bring class action or any kind of lawsuit over discrimination in the workplace. If you are going to enforce your rights, you generally have to go through the court system. Take a look at the different terms that get used in our judicial system here. It is possible to bring a class action lawsuit if you think that other people have also been hurt by a particular employer. In some cases, you cannot simply go straight to court. You have to go to an administrative agency. That's the case with many discrimination laws, such as the Civil Rights Act of 1964 that we will be talking about. You have to go first to the Equal Employment Opportunity Commission, and only if they give you what's called a right to sue letter can you then proceed on your own into the court system. Sometimes there might be a process inside your company that requires that you not go to court, but that you resolve the dispute internally. These are called alternative dispute resolution. Sometimes the method used is arbitration. Arbitration is not the same thing as mediation. Mediation is finding the middle. Arbitration is somebody deciding who's right and who's wrong with no obligation to try to find middle ground. There is a federal law that says that if two parties have entered into an arbitration agreement, including in the employment context, that agreement should be enforced. They won't be enforced, though, if they are unconscionable. For example, if the employer had considerably more power, which is often the case, and really didn't give the employee much opportunity to have a say in how the alternative dispute resolution process worked, that would be procedurally unconscionable. The actual terms of the process might be unconscionable as well, and that would be called substantive unconscionability. Here's a set of words for you. Take a look at this case in the textbook where an arbitration agreement at a company called the Jewelry Exchange was found to be unconscionable. If you're an employer, you should very carefully draft your arbitration agreement and make sure that it has the provisions that you see here, or does not have the provisions that you see here. If you're going to require that everybody go through arbitration, here are some things that you should do. It should, for example, be in writing, and you should make sure that your employees understand the terms. Stepping back for a second and looking at an arbitration agreement as a form of documentation, any documentation is important in the employment setting. If you are going to make a decision, you should write it down, particularly when it comes to performance appraisals. If you have not written it down, it is as though it did not happen. We will be covering that later. It is very important to have things in writing, whether it's your arbitration agreement or otherwise. If you are successful in enforcing your rights under employment-related laws, there are a number of remedies that might be available to you. Take a look at the remedies that are available if the Equal Employment Opportunity Commission finds that an employer has violated one of the laws that they are responsible for in this case involving the retailer AutoZone. There are a special set of rules that apply if an employer is unionized, and it's important to keep in mind that even if an employer has an arbitration clause, that would not bar the unionized employees from going to court. The Equal Employment Opportunity Commission has been increasingly skeptical about arbitration agreements. President Obama really does not like arbitration in any form. If you're the manager in a human resources department, you are responsible for legal compliance. There is no one else who is going to keep you out of trouble. You have to be the one to spot the issues, be able to think them through, and deal effectively with them. And that is the point of this course. Naturally, we don't expect you to be lawyers, but we do expect you to know when to seek legal advice. That's it for this set of slides. In the next set of slides, we will be looking at the employment relationship.